Hey everyone, Judicial Watch President Tom Fitton here with our update here on social media. Thanks as always for joining us. So much happening. It's been a little bit since I've been with you, and I want to bring you up to speed on what could be the most significant election law case in recent history. That is Judicial Watch's lawsuit in Illinois on behalf of presidential electors and Congressman Mike Bost, who are suing Illinois because in that state they count ballots that arrive for up to 14 days after election. And rather than just adjudicate the case as has been brought by Judicial Watch's attorneys, the court there said that the candidate has no right, no standing to pursue his claim in court. So we appealed. We lost the appeal, although one of the appellate judges agreed, of course, the person has standing. And then we appealed that to the Supreme Court. And the Supreme Court a few weeks ago held an oral argument in which Judicial Watch's legal team presented important arguments on the issue of standing for candidates on this key election law matter. We compiled a nice video to describe the issue legally for you in a way that I think, I suspect you'll be able to understand it. Let's play the video.
The Supreme Court of the United States is about to hear a landmark case that could reshape how elections are run nationwide. Judicial Watch is challenging an Illinois law that allows the counting of mail-in ballots that arrive up to 14 days after Election Day. That's 2 weeks beyond the date set by federal law. Even ballots that arrive without a postmark can be counted. Federal law says the first Tuesday after the first Monday in November of every even-numbered year is Election Day for federal elections. Extending the counting of ballots doesn't just run counter to federal law, it invites voter fraud and undermines voter confidence. Judicial Watch argues that Illinois' law violates federal law and threatens election integrity. In addition, we argue candidates running for office should be able to challenge these sorts of laws in court. Until recently, it was self-evident that candidates could sue to challenge election regulations. However, 2 lower courts ruled that our clients, candidates for federal office, lack the basis to challenge Illinois' practice of counting ballots received after Election Day. Standing is the legal term for this legal right to pursue a lawsuit in court. Judicial Watch lawyers responded that candidates have an obvious interest in the lawfulness and fairness of the rules that govern the elections into which they pour their time and resources. They also have an obvious interest in ensuring that the final vote tally accurately reflects the legally valid votes cast. If a candidate can't challenge the illicit counting of ballots contrary to federal law, who can? This is the exact issue now before the Supreme Court. No other legal organization has matched Judicial Watch's record in ensuring free and fair elections. The outcome of this Supreme Court case could impact how elections are run for years to come. And you can be sure Judicial Watch will continue to fight for election integrity, because no one is above the law.
So you can see it's a pretty straightforward issue whether candidates have the right to challenge whether an election is being stolen or not by saying the law is being violated here. Votes in this case are being counted that shouldn't be counted. And I don't understand, well, I do understand why the courts in these circumstances refuse to protect that right and vindicate that right by Congressman Bost and the electors we represent. And I think it's because in 2020, you had all these courts get nervous because Trump and supporters of Trump were concerned about the way elections were run and sought to intervene and try to fix the elections and make sure they were run appropriately. And there were all sorts of standing issues that were thrown out the door that had been solid law since the time of the founding. So it was disturbing to see that, and I'm hoping the court fixes it. We were ably represented by Paul Clement, esteemed Supreme Court litigator, former Solicitor General for the United States. Solicitor General is the top lawyer in the Justice Department who represents the interests of the government to the Supreme Court, and he's been before the court well over 100 times, so he knows what he's doing. Here's some clips from his opening and closing statements to the court that day.
Illinois counts mail-in ballots received up to 2 weeks after election day.
Now I'm not seeing
Petitioners
anything.
contend that under
I'm just seeing
controlling
like a
federal
weird
law,
no
that is
signal
2 weeks
pump.
too long. As a result, if the petitioner's merits theory is credited, which it must be for evaluating standing, then Illinois is counting unlawful ballots. Those unlawful ballots could cost Congressman Bost the election or at least reduce his margin of victory, and he has to pay his campaign staff for 2 extra weeks. All of that means that Congressman Bost has standing 3 times over. The court below lost sight of that straightforward conclusion only by misreading this court's precedents and misperceiving candidates who pour untold time and treasure into the election and are the ones whose names are actually on the ballot as mere bystanders with a generalized grievance. That decision is not only wrong, but dangerous. It needlessly injects federal courts into the role of political prognosticators. It risks denying judicial access to minor party candidates, and it shuffles election disputes into the closest races and the worst possible context. Election disputes after the election where federal courts are in the uncomfortable position of having to pick the political winners. There is a better way, and it simply requires acknowledging that candidates have a unique, concrete, and particularized interest in the rules of the electoral road, especially those that address which ballots are going to be counted and when. At a bare minimum, a longer campaign is a more expensive campaign, and that classic pocketbook injury is sufficient to give Congressman Bost standing. There is no need to make the standing inquiry here any more complicated than that. A candidate is not a bystander in his or her own election. Their name's on the ballot, they put their lives on hold, so they have a special interest in what's on the ballot.
Yeah, this is a pretty straightforward issue, and I talked about the way the law has been distorted, not only in our case initially, but in other election law cases outside the Supreme Court after the oral argument. Let's go to that.
I think a lot of the questions from the court suggested they're concerned about a mess in the lower courts. And, in 2020, the argument was you can't sue, it's too soon. You can't sue, it's too close. And even after the election, it's too late. And I don't think the court wants to do that anymore. And I think we're seeing a direction where the court's going to say, look, the sun rises, candidates have standing, and let's just move from there.
So I was privileged to sit and watch Paul and our election law team, Russ Nobile, who you may have seen on Judicial Watch presentations before. He's one of our leading election law lawyers. He was sitting up there with Paul Clement. Really negotiate with the Supreme Court as to what the standing requirement should be and how expansive it should be. And it looked to me, sitting there, I had a good view. I was literally front and center. It looks like there could be 7 votes, as many as seven votes in our favor, including potentially Justice Kagan. And I'm not even sure if Justice Sotomayor may not support this standing, because you have groups like the ACLU and the League of Women's Voters come in and support our standing analysis as well. So we could get a sort of ideological majority, a supermajority that upholds the right of candidates to go in and sue to prevent an election from being stolen or from being illegally run in a way that undermines confidence in elections and obviously puts the candidate in a position where they have to spend extra money and be hassled in terms of dealing with this illegalities as alleged. And it's not the only case we're pursuing in this regard. We have a case in California we were representing Congressman Darrell Issa, challenging California's counting of ballots that arrived for up to 7 days after Election Day. 7 days after Election Day. You want to know why California takes so long to get its act together in terms of reporting results? One of the reasons is they count ballots and they allow ballots to arrive for up to 7 days after Election Day. In Illinois, by the way, they don't even need to be postmarked to be counted. It's that outrageous. The good news is in Mississippi, another case that we had pursued, and by the way, we're the ones who initiated this litigation in such a successful and dramatic way nationally to challenge the 20 states or the practice in 20 states, generally, specifically in 3, that allowed accounting ballots that arrive after Election Day. They do it here in D.C. You know, you can look up the rules in your own state. It's almost half the country. In Mississippi, they count ballots that arrive for up to 5 days after Election Day. We initiated litigation there that resulted in a Fifth Circuit Court of Appeals decision finding that to be unlawful. The first appellate decision finding counting ballots that arrive after Election Day to be unlawful. And why is it unlawful? Because federal law sets election days. It doesn't set election weeks or election months. And the idea that your ballot comes in after Election Day and gets counted is contrary to any sensible interpretation of federal law that sets an election day. As President Trump, whose legal position is largely concurrent with Judicial Watch's or in sync with Judicial Watch's. In fact, the Justice Department's team argued in favor of our position, or at least most of our position. Unfortunately, they were a little weak on it, but I'll leave that aside. They agree with us generally. Trump, when he was talking about this issue in an executive order, he made the point that it's like someone showing up 3 days after Election Day and going to the polls and saying they want to have their vote counted. Too late. So you need to be sure your ballots get, if you're going to mail your ballots, and we can argue about whether there should be mail-in ballots, I don't think, generally speaking, there shouldn't be, you got to make sure they get in there by Election Day. Because in my view, federal law requires it. And states that count ballots that arrive late are acting contrary to federal law. So I talked about that Fifth Circuit success. Now Mississippi is appealing it to the Supreme Court. So it could be we're in the Supreme Court not only on the standing to challenge that lawlessness, but the actual lawlessness itself. Will the Supreme Court take up Mississippi's case and decide whether Judicial Watch is correct in its application of federal election law and that counting ballots that arrive after Election Day is unlawful? Now, when will we find out about the Supreme Court's decision? Maybe as soon as next week. They could have decided it last week, but they, what they call, the lawyers call it, they relisted it for a conference on November 7th, which is a Friday. And they typically announce the results of that conference where they talk about cases they want to take up or not take up and make decisions along those lines on November 10th. Now, is it guaranteed they'll talk about it on November 7th and they don't delay it a little bit longer? No, but it could come as soon as, I say, November 10th based on the decision they make on November 7th. So we could have your Judicial Watch team 2 cases before the United States Supreme Court on this essential matter. The issue is standing and the right of candidates to challenge elections and go to court and challenge and try to stop an election from being stolen. I mean, this could be the most important case in a generation in terms of election law. And I think the left doesn't know what to do because they, at least as I point out, the ACLU, which opposes us in every other election law case, is on our side in terms of standing. And I'm convinced that the Supreme Court is going to look very skeptically at courts or at states who want to count ballots that arrive after Election Day. Because think about it. What is the standard? How long can they wait? Can they count ballots until the next election? If not, why would there be a prohibition? How do you decide how long they can count ballots for? So that's the big issue. And Judicial Watch, once again, is front and center on this core effort to ensure that elections are fair and free and run according to law in a way that guards against voter fraud and instills voter confidence. Well, if you were relying on the left-wing media, you wouldn't know about the revelations because of disclosures by the FBI to Congress and leaks by whistleblowers to the Senate about the wild abuses of power by the Biden gang at the Justice Department and FBI and the special counsel appointed by the Biden gang, Jack Smith, in targeting President Trump and literally hundreds of American citizens and groups, including United States senators. The big news headlines have been that Jack Smith sought and spied on the phone records of, 20% of the U.S. Senate, 8 or 9 senators. They secretly got their list of people who they were calling and receiving calls from, secretly, and didn't tell anyone about it until just recently. And on top of that, there have been subpoena records showing that they were targeting not only Trump, but all sorts of groups like the Tea Party, like our friend Cleta Mitchell, Ed Corrigan of the Conservative Partnership Institute, with abusive subpoenas seeking credit records, seeking all sorts of communications with members of Congress, all sorts of First Amendment protected communications, all based on the fraudulent notion that it was illegal to dispute Biden's election. So the very pretext or predicate, as the FBI and the DOJ likes to say, for initiating this scam investigation to jail Trump, target the Republican Party generally, citizen activists at the state level involved in election disputes, groups who were just talking and exercising their First Amendment rights. They just went on a rampage of subpoenas and such, targeting them. And all of this has not been, by the way, disclosed by the Justice Department and FBI. Much of it was disclosed by a whistleblower or whistleblowers. Here's a look at the Arctic Frost subpoenas compiled by the Senate Judiciary Committee staff. And let's just go to the pages. Now, you're probably not going to see much here, but you'll see hundreds, I think it's over nearly 200 subpoenas. Everybody and their mother was targeted here. Conservative Partnership Institute, Mark Meadows, Cleta Mitchell, Justin Clark, the president's lawyers, other lawyers. They were targeting lawyers and trying to get confidential communications with lawyers, John Eastman, all of the president's top people, with outrageous bank record subpoenas, secret credit reports. They were secretly spying on these people. Now, the left likes to pretend, oh no, this wasn't spying because they're just gathering records. No, when they are secretly gathering records on you, that's spying. And by the way, some of the records show they were taping without informing the subjects of the interview. They were recording, and they were seeking to record these interviews. The FBI was seeking to record these interviews for, quote, intelligence purposes, and supposedly to criminal investigation, but in intelligence purposes as well. What the heck were they doing? And they kind of knew something was wrong. It was just reported this week over this crisis of the Senate being spied upon, that Verizon turned over all the cell phone record, all the toll records to the Jack Smith gang. But AT&T said, oh, we don't think this is legal. And Jack Smith ran. He didn't bother pursuing it because they knew it was not appropriate. So take a look at all of these lists here. They wanted to basically turn, and I've made this point before, and it's worth repeating, They were trying to destroy the entire Republican Party and conservative movement. Trump obviously was the focus, but here they were planning obviously to target hundreds of individuals with mass jailings. And I think it's only stopped because Trump happened to win. And you hear it in rhetoric now that they plan to do it again. They're not only unapologetic, they're promising to do it again. They're saying, we're going to come after all these Trump people who help undermine our democracy now. It's the same argument they used on January 6th. And who did it? Who knew? Chris Wray, Merrick Garland, Lisa Monaco. Lisa Monaco is not a name you hear a lot about, but she was part of the Russiagate scheme during the Obama administration and was number 2 during the under the Garland Justice Department. And Grassley got the opening memo from, I don't know how he got it, doesn't really matter. It was produced to him. It was the approval to open a certain sensitive investigative matter, basically targeting Trump. And this is the outrageous part of it, the executive summary. This is the basis under which the director of the FBI launched an unprecedented effort to jail a former president. Fraudulent in an apparent effort to obstruct Congress's certification of the Electoral College, fraudulent certificates of electors' votes were submitted to the Archivist of the United States, purporting to represent the actual elector votes from the states of Arizona, Georgia, Michigan, Nevada, and Wisconsin. That is a falsehood. Alternative slates of electors have been used time and time again in election disputes. You can't have a disputed election at the presidential level and expect to be successful unless you have an alternative slate. Most famously, John F. Kennedy did that in Hawaii in 1960. Open source reporting, meaning media that is anti-Trump, and public statements made by individuals closely associated with Donald J. Trump present an articulable factual basis indicating the existence of a federal crime, and thus the FBI seeks to open a full investigation. Let me see. I don't see if there's anything here that's outrageous. So it's just more of the same, and you can see the link below. And all of this material will provide links to you below as well. And so we have this wild abuse that's been exposed, and it's caused some heartache and concern and outrage on the part of those who have been targeted. They're outraged. And by senators who are outraged as well, and they want to have hearings. And I'm like, well, welcome to the party. As you may recall, I was targeted, your Judicial Watch was targeted, and indirectly you were targeted if you're a Judicial Watch supporter, because they don't like what your group is doing, your Judicial Watch that you're donating to. In retaliation for our blowing the whistle on the abuses of Trump and supporting election integrity. And I highlighted it, and I described what happened to us here. Let me go to let me play the video first, and then I'll talk a little bit more. Well, you know, I don't need to tell you, we're in banana republic territory now. The Biden administration, with its unprecedented and political prosecutions of Trump, is now officially a regime. You know, I've seen it up close. Not too long ago, I had significant skin cancer surgery. And a few hours after I got home, I'm on the couch recovering, feeling sorry for myself, when the FBI comes knocking. They came knocking on my door with a grand jury subpoena from the Biden DOJ. The agents tried to be pleasant and helpfully pointed out that something had come from me from Amazon. I suspect I am the first person in American history to receive FBI notice of an Amazon package delivery. I ended up being hassled and abused by the special counsel team for
4 hours over Trump documents, my First Amendment rights, and what I had for lunch with President Trump. It was a partisan fishing expedition. Frankly, it was like having to spend a day on an MSNBC panel. But I knew why they brought me before that grand jury. It was payback and intimidation for daring to defend Trump against their abuse of power.
I mean, isn't that outrageous? I know what happened to me. I'm talking like it's someone else, but it's outrageous. And this is the tweet I have, because obviously I'm outraged about the release of this information. A lot of my friends and colleagues in the conservative movement were also targeted. I knew that generally, but to see the specifics of it and how deep they went into the personal backgrounds, getting personal financial information, obviously trying to build a fake case to jail the entire conservative movement and turn the country into a one-party state. It's disturbing to see these documents. And so as I describe what happened to me here, look at this tweet. It's well worth considering. When the Biden DOJ, FBI, and Jack Smith retaliated against and abused me and Judicial Watch, which of course is the country's leading government watchdog group, we heard nary a peep from Republicans in Congress. We had no support, no outrage, no investigations. Instead, they kept funding the abusers. And they're still funding the abusers. This continuing resolution, there's no significant cuts to the FBI. Justice Department hasn't been significantly cut. I mean, I'm frankly tired of the Congress complaining and not doing anything. I mean, I'm glad they're releasing documents. I'm glad they're getting material out. It confirms just how deep and dark and corrupt the Justice Department and FBI were, and I would argue still are, despite the new leadership. But they're still fully funding everything. They haven't had any significant hearings on this issue yet. I mean, this is what I said about the CR fight as it relates to this scandal. I just reviewed the latest documents released by Chuck Grassley showing an abusive targeting of Trump, the Republican Party, and dozens of conservative groups, leaders, and lawyers, all of whom were targeted with countless secret subpoenas by the Biden-Obama gangs, DOJ, and FBI, Jack Smith specifically. At this crisis point, the government shouldn't reopen unless the FBI is dismantled and the Justice Department is defanged. I mean, do you think the FBI can be trusted? They're going to do exactly what they did if there's a different president who doesn't like Trump or conservatives. They're prepared to do it. It can't be trusted. And I'm sorry, these records that were released and leaked, President Trump should be asking, why haven't these been released sooner? Judicial Watch asked for Arctic frost records in January of this year. We sued in July. We've been getting the runaround on not only Arctic frost records, but virtually everything from the Justice Department and the FBI's abuses of Trump and other innocents. Yes, they're releasing some documents to Congress, and that's to be applauded. I'm not going to complain about transparency in that regard, but I am going to complain about partial transparency, and I am going to complain about a failure to follow transparency law on these issues of public controversy, especially the wild abuses of power that nearly destroyed our republic last year. So is the FBI going to investigate the FBI agents who did this? Is the Justice Department going to investigate the Justice Department prosecutors who were involved with Jack Smith? Heck, they're still hiding Jack Smith's top people from Judicial Watch. They don't want to give us their names. This Justice Department under Pam Bondi still fighting us. Kash Patel's FBI still fighting us on text messages from some of the abusers there, Peter Strzok and Lisa Page. No records on Arctic frost. No records on every topic that you're concerned about. we're getting little or no responses. I mean, the one thing they did give us was the Biden tape, showing that Biden was completely out of it. But even then, it took 6 months. And they leaked it to Axios first. So forgive me for being a little impatient, but where is the justice? Congress is releasing records. Judicial Watch can release records. Why are they giving money to these people? There's no investigation. They say there are, but there's none. At least that I'm aware of. I'm told that there should be a grand jury in Florida in January. What, 3 months from now? So what is going to happen? Well, first of all, what should happen, from my perspective, maximum transparency, get all the information out so we know who needs to be held accountable, and so we don't rely on conflicted Justice Department deep staters to tell us who should be held accountable through coordinated leaks. We want the full truth, the full list. Let's go back to these Arctic frogs. Well, I guess we don't have the full records, but when you look at the records, they're all blacked out. So a lot of the abusers' names are still being withheld. Right now, the Justice Department and the FBI are not in compliance with federal transparency law because they're protecting corrupt acts targeting Trump. That's the insanity we're in. So when you see Trump say he's impatient and why aren't things being done, there's a lot behind that. He must surely know that. And if I were President Trump, I've said it once, I've said it before, he's the magistrate in chief. He should run the investigations directly and directly run the prosecutions, have a special counsel report directly to him, staff it with people who aren't conflicted, no FBI guys, no DOJ prosecutors. There are plenty of other law enforcement types in the federal government he can use. They can bring in private entities, private individuals. And the prosecutions would be run like other federal prosecutions with all due respect for civil rights and before grand juries and typical investigations. But the president is the prosecutor in chief. They've already demonstrated they can't get it done. I mean, look at the, even, and I do think they do want to get some things done, and I do think there will be certain things done, but it will be woefully insufficient. Look how painful it was to get that Letitia James indictment done. Look how painful it was to get that Comey indictment done. It's only the tip of the iceberg. And they still haven't gotten Jack Smith before a committee in Congress. They still haven't gotten. And they're still fully funding this FBI. So we're going to keep on fighting in court for the full truth here. And I'm going to keep on pressing. It's not because I dislike Pam Bondi or Kash Patel or Dan Bongino. I admire them all. I just, on behalf of Judicial Watch, strongly believe we need a radically different approach to handling these abuses of power that nearly destroyed our republic and got President Trump killed. It's not just they wanted to jail Trump, they wanted to see him dead. Further confirmed by their celebration of Charlie Kirk's murder and assassination. And I tell you, if the FBI is still around in its current form, when a Democrat president comes in, or even maybe a Republican president, a loser Republican, it's all going to start up again. And they're running out of time. Arguably, they've already run out of time. And this is why it's so important to support Judicial Watch, because we're not afraid to tell the truth. sometimes get our friends mad. And we are not afraid to sue the government, even if it results in my being called before a grand jury to be questioned about my tweets by lunatic anti-Trump prosecutors. So more FOIAs, continued lawsuits, and more are coming to get to the heart of the worst corruption scandal in American history, courtesy of Judicial Watch. And I encourage you to call your members of Congress and senators saying, what are you doing? A hearing isn't enough. Press conferences aren't enough. We're going to have the same FBI funded at the same levels that we've had forever. Same Justice Department with the same abusive authorities. They got to have their wings clipped. And Congress can do that and must do it. And in the meantime, Judicial Watch will keep on keeping on because we don't trust Congress and we don't trust the deep state agencies to get it done. So with that, thanks for supporting us. Be sure to get my new book, Rights and Freedoms in Peril. It's now out in paperback. It just came out in paperback. You can get it at your favorite online bookseller, or dare I say it, you can go to a bookstore and still get it, maybe even to a library if you can't afford it. But I encourage you to read it because it tells you what needs to be done and the scope of the scandals involved. It can't be just everything is normal. This is a crisis point, and your Judicial Watch is on it. Thank you, and I'll see you here next time on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.